Okay, so to start, there are many different ways an individual with intellectual and developmental disabilities can get involved in the criminal justice system, just the same as a neurotypical person can. They can be victims of crimes, which occurs often at a high rate. They may be suspects or offenders. Today, we're going to be focusing on their involvement in relation to being suspects and offenders in the CET, but it's important to also note that they do have a high risk of being victims as well. Research varies for the prevalence of individuals with IDD involved in the criminal justice system. Oftentimes, data is focused on arrest and conviction rates, not representative of true offending behaviors and incidents. There has also been much more research focused on recidivism rates rather than understanding the path of criminal offending. There is a higher prevalence of borderline to mild ID within the criminal justice system. Very few individuals with moderate to severe ID are found. It's perceived that this is a reflection of their high dependency and supervision of caregiving. They have a diminished capacity to stand trial and or the poor likelihood of conviction. Individuals with intellectual disabilities comprise 2% to 3% of the general population, yet they represent 4% to 10% of the prison population, with an even greater number of those in juvenile facilities and in jails. I just wanted to provide some quick data on the prevalence of serious mental illness among all people entering jail. It's estimated that 16.9% of all people entering the prison system have some type of a mental illness. 14.5% of those are men, 31% of women. Although the focus of today's CET is obviously on the IDD population, I didn't want to ignore that the mental health symptoms present in all the individuals that we support also play a role. Although I was unable to find some direct data and research on the IDD population with comorbid mental health concerns entering criminal justice system, it definitely is important for us to all recognize that this is a prevalence that warrants research and exploration. So the relationship between intelligence and offending has been widely investigated and reviewed. The majority of studies have demonstrated that similar characteristics and risk factors within the general population also lead people with ID to having increased contact with the criminal justice system. So some of these factors include their youth status, gender being male, a psychosocial disadvantage, familial offending, history of behavioral problems, unemployment, and comorbid mental health needs. Some cognitive disabilities could increase an individual's propensity for crime. So for example, a person with a lower IQ may not realize that taking food from a store without paying is illegal, or that their unreturned expressions of affection border on harassment. People with a lower IQ and other developmental disabilities can engender suspicion because they lack the necessary social cues that other adults may understand, resulting in inappropriate responses. People with cognitive disabilities may also say what they think the police want to hear, even to the point of confessing to crimes that they did not commit. They may waive their Miranda rights without realizing the repercussions of doing so, while saying that they do understand. Cognitively disabled people may fail to understand the seriousness of a situation and often lack the resources to post bail. During court hearings, they struggle to comprehend abstract legal concepts and to assist in their own defense. They may alienate juries by smiling, sleeping, or staring, giving a false impression of callousness or a lack of remorse, resulting in higher rates of conviction than the non-disabled. There have been some court cases that have changed how people with IDD are represented within the criminal justice system. So just to briefly review those, in Clark v. California in 1997, the court recognized special needs offenders are vulnerable to physical, sexual, and verbal abuse, exploitation, theft, and harassment, and that they require accommodations from the usual routines of incarcerated life if they are to be safe and able to participate meaningfully in facility activities. In 2001, the California Department of Corrections and Rehabilitation and the plaintiff agreed upon the Clark Remedial Plan. the narrowest, least intrusive set of procedures that could effectively ensure adherence to federal law for the developmentally disabled. And in Atkins versus Virginia in 2002, in which the Supreme Court ruled that the execution of any person with mental retardation, now known as intellectual disabilities, violated the Eighth Amendment's prohibition on cruel and unusual punishment. Over to Andy.
All right. Thought it was kind of important to mention about police interaction with our individuals, because I'm not sure there's always enough training, and I think things could get misinterpreted when there's interaction between the two. Something as simple as eye contact. You know, growing up, you remember whether it's a parent or a teacher, you know, look me in the eye, you know, show some respect. Well, that's not going to come very easy to a lot of our individuals, and that could be seen as oppositional, disrespectful, and of course, we know it's not. It's just something that doesn't come naturally. A lot of misreading of social cues, things we take for granted. Imagine a police officer with his arms folded, rolling their eyes, body posture showing dominance, and that just could be totally lost on the individual. So unless there's some training and understanding of that, that's absolutely going to lead to an escalation in situations. Now, Elise started to hint at it, but behavioral health symptoms also are going to be exacerbated by poor verbal skills. The individual is not going to say, hey, I'm afraid, you know, what are you doing? Leave me alone. They may just get angry, or they may just not respond at all. They won't explain what they've done or what they're doing at that moment. I don't know if any of you have seen that TV show Atypical on Netflix, but there was a phenomenal scene where this very high functioning star of the show, who essentially has Asperger's, although that diagnosis doesn't exist anymore, and the police were wanting to ask him questions. So what did he do? He put his hoodie on and he ran. Now, you tell me if you can think of a worse thing to do when a police officer is looking for you, but to put on your hoodie and run. So I thought that was a great example of the lack of communication. Now, anxiety and trauma is on this list because that also affects it. Think about anxiety and trauma situations, people who have been through that. They're going to have sensory overreactions, a loud voice, a loud sound, being touched, and they're going to react in a way that doesn't seem logical to the situation, or it seems disrespectful. But they may be having a flashback of fear, a body memory, and they're looking to escape. And what we want the police to understand is that's not purposely disobeying authority, it's not criminal activity, but it's based on their underlying disorder.
Another show that this was really well shown in is the Netflix show Making a Murderer. Anyone that has seen that with the nephew of the star, and again, this is a true story, a documentary, you know, had some level of intellectual disabilities. I actually dug into this. I got to read a psychological. It was very interesting because that's what I'm interested in. But he had a lot of what Dr. Kent was talking about. You know, he wasn't making eye contact. He misread their social cues. Some of the things I spoke about with just saying what he knew the police wanted to hear. He waived his rights for representation and for his mother. He was actually a minor as well at the time, and he waived all of that. And he is still in jail many, many, many years later. And seemingly was not involved in the crime. So again, a lot of things that Dr. Kent and I have already spoken about were shown in that documentary on Netflix as well.
All right, so it's not unusual for those with intellectual disabilities to have coexisting mental health disorders. And this is going to further impact how they're going to interface with the law. Let's take depression, for example. If someone's very sad and gives up on life, they're not going to care about getting in trouble. They may do things to hurt themselves. In our individuals or group homes, we may see things such as cutting, biting themselves, burning themselves, and this can result in the local authorities being called. Once again, it's important to treat these individuals with compassion as they are feeling so poorly and out of control that they're doing this to themselves. It's not an aggression towards others. Manic behavior, that could be even more dangerous. And individuals whose thoughts are racing cannot stop to be rational, and having a conversation with them in that moment to try to explain that they're wrong, it's not going to be fruitful. An individual in the throes of mania needs to have as little stimuli as possible. They need to be put in a calm situation. They may be severe enough to require restraining or emergency medication. Now, the safety of the police or those around is paramount, but it's important to understand that there is not premeditated intent to disobey, but rather illogical loss of control. Impulse control disorders, that's a very slippery slope topic because it doesn't mean all individuals with impulse control problems don't know what they're doing. There's a large gray area where someone could be impulsive, but they have the ability to control it and certainly some understanding of what's right and what's wrong. We all know many individuals with ADHD who are hyperactive and will speak or do things without thinking, but they are aware of the potential negative consequences and responsible for their actions. Tourette's is an interesting one. By the way, that'll be our June CET, so it's a little promotion for that one. Motor movements and verbalizations are out of control. Tourette's can lead to screaming, cursing, odd motor movements, and this could be misinterpreted by the police if they're not aware of this as a disorder, that this person is being aggressive and again, disrespectful. Now, depression, I wanted to bring up death by suicide by cop, which we've seen about certainly in the lay press. The individual wants to die and the police suffer terribly because they're put in a horrible situation. And again, no one's saying that if someone's life's in danger, the police may have to act how they have to act. But if they have mental health training, or if there's an individual on the site with mental health training, you might be able to get into a negotiation. You might be able to work with them on their depression and self-injury thoughts and take them down in a less lethal manner. Now, psychosis. Psychosis is really hard for someone to understand if they've not learned about it. It's human nature to think if an individual says something outlandish like, microwaves are coming into my head, space aliens are telling me what to do, that it's made up. But all of us in the field kind of know that bizarre psychotic hallucinations and delusions exist. So we want them to be able to factor that in and understand that. The more police, school districts, and those who interface with individuals out in the community could understand this, the more helpful. Now, substance abuse is another factor. There are certain illegal drugs that result in manic and psychotic presentations. Likewise, withdrawal can also lead to an individual perhaps acting odd, maybe having a seizure, and certainly not presenting in a normal way. And I just want to throw one other thing that I didn't have on the slide, but I actually realized it this morning. Even something as simple as a medication change. This individual was on, let's say, Zoloft and Vyvanse, I think. If that was just started, that can cause disinhibition and agitation that the person never had before. So they may do something more impulsive, get into trouble, and that has to be factored in. What's their medication regimen? And is that also adding to the behavior that's causing the authorities to be called? So you can see in summary on this slide, there's multiple mental health conditions that impact an individual and how they may be introduced into the legal system.
Before we move into the mental health courts, because I know this is going to kind of take a turn for where the presentation's going, I just want to bring it back to Alice for a second. So, a lot of what Liz spoke about, but also what was in the document that you all were able to read previously, it really talked about her inhibition, her executive functioning deficits, her desire to be socially accepted. And that all really put her at a disadvantage in regards to her now criminal charges, felony charges, misdemeanor charges. Again, we're not saying that she did or didn't do the crime. That's for the judge to decide. But the reason that she was there was related to her social deficits and to her desire to please. We don't have enough information on how the situation went down with the police in the moment, but it's possible some of what Dr. Kent and I have spoken about occurred in regards to when the police, first arrived and first, investigated her. Was her demeanor off, air quotes in that one, and that led them to have a harsher response to her? Did she admit to something because she thought that's what they wanted to hear? So again, just to bring it back to the case before we move into the mental health court system, which is equally important in this topic, I just wanted to bring it back to Alice of she really represented a lot of what we've talked about thus far. And again, she spent 8 months in prison, in jail, and hasn't even been charged yet. So there's a huge disservice there, but what brought her into the criminal justice system was definitely related to her deficits. So back to you, Andy.
Sure. So mental health court history. When I did my forensic fellowship in psychiatry, I worked at Bellevue, I worked at Rikers and Kirby Forensic Center. We didn't have mental health courts. The people we saw were really the square pegs trying to fit into a round hole, and it was a disaster. Over time, it was realized that a different system needed to come into place. And in 1997, in Broward County, they came up with the first court. And in 2002, New York established the courts with the goal of diverting these individuals from the regular court system. Now, initial research at the time found about 15% of inmates had significant mental illness. And it varies, like at least before, I think hers was 16.8, 0.9, something like that. So you see it varies. But as they did more research over time, the general population increased, but the amount of inmates that had psychiatric diagnoses just skyrocketed. And what's important to know, this wasn't just one area. This wasn't just Brooklyn or Bronx or Queens. You know, we live in New York and there's a lot here. This was all over the country. It was replicated. So you could see that the amount of influx of mental health cases into the prison system really needed to be addressed. I never participated personally in any official studies at the places I worked at, but I can tell you when I worked at multiple prisons, the numbers were immense. The other thing is that many of the individuals who had disabilities and committed crimes, they didn't have any money to get out. So they sat there until the case came to trial. They did not get bailed out. And when they languished there, they were treated terribly because of their vulnerability. And I'd like to say it was only by the fellow inmates, but it was also by some of the staff that were there. So this is a very important point that we have to advocate for these people to get them the proper representation and get them out of that system. And the mental health court was intended to do that.
Okay, so as with many other collaborative initiatives, mental health courts are designed to bridge systems and agencies. The criminal justice system was not designed to provide mental health treatment. Its main purposes are to ensure public safety, promote justice, and punish and prevent criminal behavior. The mental health system, in contrast, focuses primarily on the treatment of illnesses, public health, and harm reduction. So despite these differing mandates, the two systems have been thrust together because of those overlapping commitments to the same people. Mental health courts attempt to coordinate these responses under the purview of the court so that each system can fulfill its duty and produce the best outcomes for people with mental illnesses in their communities. Despite general similarities among mental health courts, each court develops locally based on the need and legal regulations of the particular jurisdiction and the treatment services available. So as a result, there is no single mental health court model. So even on Long Island, Suffolk does it differently than Nassau. They are separate entities. So that is always important to remember. In addition, in general, mental health courts are increasingly likely to accept individuals charged with more serious offenses, including felonies, and in some jurisdictions, violent crimes. Most mental health court participants have serious mental illnesses, and many have co-occurring substance abuse disorders as well. The mental health court team members include a judge, representation from the defense bar and the district attorney's office, probation or parole officers, and case managers or representatives from the mental health system. Referrals to a mental health court program most commonly come from defense attorneys, judges, jail staff, or family members. The mental health courts employ incentives and sanctions tailored to the circumstances and needs of each participant to motivate them to engage in treatment and comply with the terms of their participation. Participants in some mental health courts have lower rates of recidivism, and in particular are less likely to be arrested for new crimes than individuals with mental illnesses who go through the traditional criminal court system. These empirical evidence show this trend continues after graduation when individuals are no longer under court supervision, which is very positive. Mental health courts are more effective than the traditional court system and jails at connecting participants with mental health treatment services. And over time, mental health courts have the potential to save money through reduced recidivism and the associated jail and court costs that are avoided, and also through decreased use of the most expensive treatment options, such as inpatient care. So New York Mental Health Court has several goals of its system. So the first is improving public safety. Many people living with mental illness repeatedly cycle through the criminal justice system, as we all know. So linking these individuals to community-based services and treatment is designed to reduce this cycle of recidivism. A reduced length of time in jail or prison for offenders with mental illnesses. Mental health courts seek to reduce both the frequency of arrests and the duration of incarceration of justice-involved individuals living with mental illness, for whom community-based treatment is an appropriate alternative to incarceration. Using overtaxed criminal justice resources more efficiently. So mental health courts reduce the frequency of contacts between law enforcement and people living with mental illness, improving court operations in cases involving justice-involved individuals, and minimizes strains on correctional facilities caused by incarcerating people living with mental illness. Another goal is to improve the court's ability to identify, assess, and monitor offenders with mental illness. So this is done by equipping the courts with tools necessary to perform meaningful assessments, identifying appropriate treatment options, and make connections to the mental health system. Mental health courts also provide judges with the means to make more informed decisions about cases involving justice-involved individuals living with mental illness. There's also a goal of improving the quality of life for people living with mental illness. So mental health courts seek to reverse the recent trend towards criminalization of mental illness, a term that describes society's use of the criminal justice system to respond to behaviors associated with or caused by their mental illness. Instead of incarcerating these individuals, mental health courts help to connect them to community-based treatment and support services that encourage recovery. And lastly, improving coordination between the mental health and the criminal justice system. In bringing together criminal justice and mental health stakeholders and involving many parties in the planning, implementation, and implementation process, mental health courts are catalysts for cross-training and systems improvement programs.
Okay, 730 assessments. 730 exams are assessments to see whether an individual is competent to stand trial. The landmark case was Dusky versus the United States in 1960, and it affirmed the defendant's right to have a competency evaluation before proceeding to trial. Prior, if the individual had no clue about what was going on, they could still really be pushed through the system. It just didn't matter. One important thing to distinguish is the time of the assessment. A 730 exam is not looking at the mental state of the person when they committed the crime. It's irrelevant. They're looking at the time they're being evaluated to go to trial. It's clearly not always the same, as someone could have decompensated and got worse, or conversely, someone actually could have gotten better since they committed the crime. The goal of the evaluation is to see if the person understands and can participate in the trial. These are a basic mental status exam, although if the case is more complicated, psych testing can be added as well. It could take 45 minutes to an hour, but frankly, if it's a simple no-brainer one, sometimes they could be done a little quicker. Conversely, in a very high profile or difficult case, they can be held and tested and observed over days to weeks. Son of Sam was a perfect example. They held him for quite a while. They wanted to get that one right and certainly knew there'd be a lot of public scrutiny. If the individual is not competent, they go back to treatment to obtain competency. It does not mean, make this very clear because this is always mistaken, it does not mean the case is dropped. It does not mean they're getting away with it. They go back for treatment to obtain competency because that's a very, very common misconception. Now, the question is, what if they never become competent? Well, then ultimately the charges are dropped. They are civilly committed and they are held until they are found to be safe to return to the community. But the goal always is to achieve competency to go back and face your charges. So what's the criteria? Simply, if you can participate in the trial, you have to know what's the role of the judge, what are my charges, what's the prosecutor supposed to do. So very simply, you want to ask them friend or foe, basically. Hey, they trying to help you? Should you help them? No. What's the jury's job? What's the attorney's job? Sounds simple, but it could be a little tricky. I'll give you an example. What if it's a political prisoner, someone that dropped the bomb somewhere for political reasons? They're going to say, hey, this system is rigged. The judge is paid to put me away. So is that paranoia? Does that mean they can't contribute because they don't trust the process? Perhaps they're a little paranoid, but they understand the process. It's a matter of not trusting it or believing in the system. It's not psychosis. And what you have to do then as a mental health professional, as a psychiatrist, is you got to look outside for corroborating evidence. Outside of this, was the person psychotic? Did he or she have interactions with family, with employers, with the school system to show that there is a track record? Because you don't all of a sudden become psychotic at the time of the trial, although a good defense attorney may want you to think that. So as simple as this looks, it could be complicated. And that's when the 730 isn't about just sitting for 30, 40 minutes with them, but getting all the evidence and data from other parts of their lives.
I just want to even bring up a past case. I'll call him Charlie. And anyone that was involved in this case knows probably who I'm going to talk about right now. We had a case with START for a very long time. And ultimately, he did have some criminal activity while he was in a local hospital. And he was charged. We fought for a 730 assessment, and he actually passed. And it was shocking to us. He had moderate ID. He was diagnosed with schizoaffective disorder, I believe. And we were all really shocked, and it was, when we talked to Dr. Ken about it, we realized the threshold to pass was much lower than we had hoped. Ultimately, he did not pass later on after he violated probation. And I use violated a little bit loosely, but he now is in a developmental center getting additional support. But when he passed and he had to sit for his charges, and he was in jail for, I believe, 9 months before being released to residential treatment, it was a shock to our system that he did not meet the criteria for mental health court and did not meet the criteria for 730. So I just wanted to add that it is a lower threshold than I think anyone, at least in the START team, really had hoped, especially for that young man, but really for others. They really do look at the mental health. Obviously for that case, there was both, but the ability for him within his intellectual disability was very strong. And we were very surprised that he passed his initial 730. I think they did it either 2 or 3 times as well at our request. Even the social worker working with him, was surprised at some instances as well. So I just wanted to kind of add that there is a low threshold for passing.
All right, well, as a member of START, I was more disappointed than shocked.
Yes, true.
I've done a whole bunch.
We were both. You're used to the process more than we were at the time.
Yeah. All right, so let's talk a little bit about criminal responsibility once you get past the competency question. It's important to know that when planning defense, you're looking at the mental state differently than the competency. You're looking at the time of the act. What the mental state was like when they were younger is not relevant, nor is it what the time of the arrest, nor is it at the time of the trial. What was their mental state at the time they committed the crime? Mental health defense is very controversial, and it gets much more attention on some level than it warrants because it's not used successfully all that much, but it's kind of a sexy topic. The other point that people often miss is that if somebody is found not guilty due to insanity, again, it does not mean they'll be released or again, they got away with it. In fact, without the limited constraints of a legal sentence, they actually could be held even longer under a psychiatric commitment than due to a sentence. This is why when I worked in the jail, individuals with lower level crimes really did not want to go down an insanity defense path. They just wanted to do their time and get out because they knew it would be a lot faster and cleaner process. So as I said before, it gets notoriety in pop culture, a lot of movies and TV, probably stuff Elise likes to watch, covers this stuff a lot. Hollywood loves to focus on the individual faking the defense. I don't know if you guys remember Edward Norton in Primal Fear. He gets in there, he's found not guilty, and in the end he claps and laughs, and he pulled one over on anybody. I was actually fortunate enough that I was part of the team that trained Richard Gere for that role in that movie. And it was probably the time my wife was most interested in what I did for a living, because she only wanted to meet Richard Gere, which I got her to do, and that was, so she was happy as all hell. But it's super popular in Hollywood because it's so interesting and fascinating, and people are really afraid of, you know, individuals getting away with crime. But again, it does not happen that often where it's, you know, an out and the person gets away. Now, the real life case that impacted how we look at the defense in America was the Hinckley case. And that's who shot President Reagan in 1981. The attacker had a psychotic delusion of erotomania to Jodie Foster. And according to the records, it wasn't a close call. He was psychotic and he met the criteria for the defense. But you could well imagine how a lot of this country reacted when he successfully used that. He was held from 81 to 2016 and released. There was great anger about him ever getting out because he shot a US president, but he was no longer a danger to himself or others, and he was rightly put back into the community with protections in place. So people love to argue about the defense, and any civilized society, though, we really do need a place to address individuals who don't truly understand right and wrong, and they don't really have evil intent. They can't be lumped together with sociopaths who commit crimes for other reasons. Problem is, it's extremely tricky because societies define insanity differently, and people are understandably fearful that it can be misused to let individuals get away with things and not face the consequences that they deserve.
I think an important piece for Alice's case, especially since she hasn't even sat for her charges yet, is that what Dr. Kent said about mental state at the time of the act. So, you know, we have done, you know, this full case review in preparation for the CET. And, you know, so we see how, you know, her development and her limitations have impacted her over time. But in supporting her defense and supporting her legal team, we want to also make sure that we can provide them some information about her mental status at that time. So looking at those records, looking at the time that this occurred in her life, what was going on for her, how her ID and mental health was impacting her decision-making. So I do think that since Alice has not sat for her charges just yet, it is important that we kind of keep that in mind, as well as we'll be, you know, collectively, her system will be a part of that process.
Yeah, that's a great point. I just want to follow up that whoever's evaluating her, we'd want to know what meds she was on at the time. That day or two, were the meds changed? Did she miss her meds that week? Did she get her meds? We get a CVS printout that shows that, you know, what her friends and family, if they could remember. So it's a lot of detective work for the systems, but it's so critical to that time when they picked her up. To look at all that stuff and not just assume that Friday or Saturday she was the same as she was a couple weeks prior or a couple weeks after. Mm-hmm. Yeah, so I'm glad you brought that up. All right, so the Mcnaughton Rule. This is the law that our society is based upon. The psychiatric defense comes from this, although it's been modified. And this came out in the 1800s and it originated in England. What it states is that every man, and today obviously we're going to put man or woman, is presumed to be sane, and to establish insanity, it must be proved that at the time of the act, there was such a defect of reason from disease or defect that they did not know the quality and nature of the act, or if they did not appreciate that it was wrong. This is a wonderfully written statement, and there's really a lot to unpack. Look at the first line. Every person is to be presumed to be sane. Why this line is so important is that it's incumbent on the defense to prove the insanity. It is not the role of the prosecution to prove that the person's insane. This isn't a trivial point at all, because the jury is instructed you are to assume this individual is sane and needs to be responsible for their actions unless the defense beyond a reasonable doubt proves that the psychiatric illness meets the criteria. And this is frankly a major burden for the defense to do, as it should be. So that's a super important thing. The other part I wanted to point out was that where it says that due to disease or defect, the individual did still know the quality or nature of the act, it's still possible they meet the criteria. Where this comes into play is when an individual knows what they're doing is wrong, but they did it for a psychotic reason. I'm going to give you an example. When I worked at Bellevue, we had an unfortunate woman who threw her child out the window to its death. She had postpartum psychosis and felt the child was the son of Satan and was going to kill others, and God was instructing her to do this. The woman had no legal history, and after interviewing family, friends, and neighbors, it was clear she had deteriorated severely into a postpartum psychosis. She was rightfully found not guilty by reason of insanity, although she knew she was destroying and killing the child. She was placed in psychiatric care for a very long time, rehabilitated, and ultimately released on proper medication. It was a brutal case, but it demonstrates the intricacy of the Mcnaughton Rule and what constitutes lack of responsibility. All right,
I just heard someone unmute. Did anyone have a question or a comment? I can't see everyone on the screen while it's shared. Okay.
All right, so here I obviously mentioned the first case. Second one I thought was another one that sort of demonstrated it. There was a man who parked in a rest area on the Long Expressway. He set up a gun, and he was being told in his head by people from outer space that they were coming to take over the earth, and it was his job to protect them. He was told the particular area, the time, and he started shooting at cars on the Long Expressway. And this was in the 90s. Fortunately, nobody was killed. I think there were some injuries. This was a long time ago. I don't remember it that well. The prosecution argued it was premeditated because he planned the time, set up the gun, and waited. When I was on the stand, my point was, yes, it was very well arranged, but it was irrational and it was illogical. There was no financial gain, no revenge factor, no possible reason to do it other than because of psychosis. This is not an angry man who was trying to get even with somebody, nor was it even impulse control problems from being frustrated or wronged in some way. It was not a political statement. There was no religious agenda. It was my medical opinion at the time that his act was the result of mental disease proven by the defense beyond a reasonable doubt, and that he did not appreciate the wrongfulness in his mind because he was protecting the community. So my goal up there was to turn their argument into my strength. His plotting and his arranging this in such a manner was proof of his psychosis. Now, I have to tell you, I was nailed on the stand. They were not happy with me because it was in the press and it looked really, really bad. But in my mind, it was clearly psychosis. That was actually the way the case went. And he went and was psychiatrically hospitalized.
I was on a jury once when it was a man who was caught selling drugs to minors in a park, and his lawyer was trying to go for this Mcnaughton Rule and prove that he was, insane and going through, some type of a psychosis episode. They ultimately got me thrown off the jury because of my experience, but they did not prove that he was insane, and it was a very far stretch to prove that. He wasn't. He was a drug dealer, but seeing that in action and seeing those attempts was very interesting. I wish I didn't get thrown off because of my profession, but I think they realized they weren't going to convince me of that, and they ultimately got me replaced. But these are really great examples of when it is used. But again, there's probably a whole host of examples of when it's attempted and not successful as well. Is this me?
I think so.
Yes, it is. Okay. I got lost in the shuffle. All right. So in criminal law, irresistible impulse is a defense by excuse. So in this case, some sort of insanity in which the defendant argues that they should not be held criminally liable for their actions that broke the law because they could not control these actions, even if they knew them to be wrong. It was added to the Mcnaughton Rule that Dr. Kemp just reviewed as a basis for acquittal in the mid-20th century. The concept of irresistible impulse was developed in 1960, a case of R versus Byrne. The appellant was described as a violent sexual psychopath. He strangled and then mutilated a young woman. It was alleged that Byrne suffered from violent and perverted sexual desires, which he found impossible to control. This broadened the definition of abnormality of the mind to include those lacking the ability to exercise willpower to control acts in accordance with their rational judgment. Irresistible impulse can be pleaded only under the defense of diminished responsibility, not under the defense of insanity. Thus, it operates only as a partial defense to murder, reducing the charge to manslaughter, and giving the judge discretion as to a length of sentence and whether committal would be more appropriate than incarceration. In 1994, Lorena Bobbitt was found not guilty when her defense argued that an irresistible impulse led her to cut off her husband's penis. The Insanity Defense Reform Act, passed by Congress in 1984, imposed a uniform standard for legal insanity that applies in all federal trials in which the defense is raised. It also established the burden of proof in such cases. Although criminal law is primarily the province of individual states, the federal government has independent jurisdiction to prosecute criminal activities that concerns federal government. In 1984, all states and the federal criminal law had some version of the insanity defense, but the federal criminal code did not contain an insanity defense. Instead, each of the courts of appeal in the 11 federal judicial circuits had judicially adopted an insanity defense that applied in that circuit. 10 of the 11 circuit courts of appeal had adopted the American Law Institute's model penal code, insanity defense, which permits acquittal by reason of insanity if, at the time of the crime, as a result of mental disease or defect, the defendant lacks substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. The Penal Code of the U.S. State of California states in 2002 that the defense of diminished capacity is hereby abolished. Therefore, there should be no defense of diminished responsibility or irresistible impulse. So California got rid of this ability in 2012. The policeman at the elbow test is a test used by some courts to determine whether the defendant was insane when they committed a crime. It's a variant of the Mcnaughton Rule that addresses the situation in which the defendant knew what they were going to do was wrong, but had no ability to restrain themselves from doing it. The test asks whether they would have done what they did, even if a police officer was standing at their elbow, hence its name.
I was just thinking when you went over that slide that nothing will get a bunch of old men to change the law faster than reading that a woman cut a guy's penis off.
Exactly. I figured that was a case that everyone would know.
Yeah, they should be so kind to women's rights. Not always. So, okay.
No.
Well, we won't get too political here, but okay. Guilty but mentally ill. That is a alternative that I never liked in my training. It kind of basically splits the difference. And what it did was it allowed people to be not handled in the penal system, but to be remanded to a psychiatric facility, but they had to finish the sentence even if quote unquote cured, like a not guilty by reason of insanity. But the thing is, if it was due to psychiatric illness and they were better, does it really make sense that they're handling a sentence that was based on a legal, finding? So I never really liked it. Michigan, I believe, has kept it. Some other states have kept it. Most places do not. Where I did like it as a psychiatrist in sort of a self-serving way, it's easier to release people after that because you could just say, hey, they did their time anyway. Because there were cases I used to get from Riverhead that the most heinous of crimes, and the people were found, NGRI, and they were restored to sanity, and they were treated, and they were doing better, but didn't go anywhere near finishing out their sentence. And when that's in public, that's hard as a psychiatrist to sign off to get someone out, because in your heart, they're on their meds, they're safer, but the public pushback is going to be awful because what they did was so disgusting and so public. And God forbid you read that they did something and you feel responsible for it. So I think guilty but mentally ill was sort of a compromise, but it really, by splitting the baby, so to speak, I don't think it really did much for either side. So it's kind of fallen out of favor, like the irresistible impulse. And just to go back to that one for a little bit, that was so untenable because we had people then doing gambling, gambling debts they couldn't resist, sexual crimes because they couldn't resist. So they had to pull that one back because it was just, it was being misused. I think it was with good intent that it was developed, but it really wasn't, a tenable way to fit into the legal system in the US.
I forget the name of the woman, but I just read an article yesterday. I think the Today Show posted it or something. And it was from a case from that really spanned, I want to say last summer, early fall, where the woman and her fourth husband were found to have killed her two children. Sorry, my dog is not liking that story. And they, had run, and they, they couldn't find them, and there was a whole big story. But just yesterday, it came out that she was deemed not able to sit trial due to her psychiatric functioning. I don't know about the husband or the fourth husband, but there's also many charges pending because they now are believing that she actually killed the other three husbands prior to the current husband, as well as her two children. So it's a very complicated case, but just yesterday I read the article that they actually did deem her unfit to sit trial, and they're going through what that's going to mean for her within her rehabilitation and all of that, as well as her additional charges that are coming. So just a very present case that came up literally just yesterday that is looking at the plea of insanity.
Maybe as the clinical director, we do systems outreach. You could outreach to Dateline and be a consultant.
Maybe. And that's the end of our training today. I'm going to stop share so we can all see each other and see if there are any questions or comments. It looked like while we were doing that, we had a couple of people join us. So hopefully you were able to join us for the majority. Anyone have any questions or thoughts on this topic?
I love that you guys, hi, it's Lisa. I love that you guys brought up the 7:30 exam. Charlie was the first case I thought of with that stuff. Yes. So it's just interesting how there is that little bit of a gap and how, people are just developing and understanding more about the neurodiversity and what that looks like in the system. So this was really awesome and informative, and thank you guys.
Thanks.
I'll kind of add, I'm currently supporting a case, we'll call him Craig, I don't know, who is also, receiving some upcoming criminal charges. And, while I can sort of understand that they're pending right now and that they were pretty violent and destructive in nature, I can justify that. But what kind of landed him in the criminal justice system on the onset was an arrest for cyber stalking. And while I feel sympathy for the girl that experienced this level of stalking and not justifying that, but as a result, he landed in jail for roughly 20 to 25 days as his sentence. And as a young man with autism, his social understanding and those social cues are a large deficit. So he may not have necessarily realized what he was doing was so bothersome to this young girl. And as a result, while spending, a couple of days in jail or, a little under a month, he was sexually assaulted. So now we're looking at a whole slew of traumatic experiences, which are likely contributing factors towards the aggression and the new charges that he's facing. So, it's just so potentially counterproductive. And I use the word potentially because I'm by no means justifying any, dangerous acts or, disturbing this young woman's day-to-day life. But it's just so unfortunate that if he would have potentially received treatment, and a better understanding understanding social skills groups, learning about boundaries, how to have relationships, things along those lines, maybe he wouldn't have had jail time, and he certainly wouldn't have experienced that sexual assault, which is extremely traumatic for him. So I have to shake my fists at that. That's what I'll kind of end that. I don't really have a conclusion, but currently, working on this case, and just very disheartening to me that that's sort of, how it ended up unfolding to a certain degree. And he could have had these violent episodes, despite the traumas that he experienced. And I'm sure that was not the first time that he had been violent, even prior to his jail time, but he just didn't belong in jail for 28 days for cyber stalking. He could have learned those skills potentially somewhere else. And I'm such a big person for, rehabilitation instead of punishment. So that's shaking fists.
Well, listen, I have one I want to mention. It'll make you feel a little better where we're helping. I did a consult at our resource center with a young man who is very religiously preoccupied. And I sat down in the backyard and we were talking. And he said God has told him he needs to be fruitful and multiply with a particular woman that he loves from high school, and he wants to keep visiting her. And I tried to explain to him stalking versus affection. And we're going to get him into some spiritual counseling, and we are addressing it. So he's someone I think we're actually catching right before he goes and does something like that. So I think we can do good and prevent some things like that.
Yeah. Avi, you can unmute.
Yeah, so I'm curious, actually, you mentioned, Dr. Kent, you mentioned spiritual counseling. I'm wondering, why did you go straight to spiritual counseling instead of just general counseling? I'm curious about why you specifically went that way.
Yeah.
Well, in Monopoly, it says, do not stop, go straight there. The family doesn't believe in traditional counseling. It would have been rejected immediately. And he has a sense of trust in spiritual people. So I think it has to be the right spiritual counselor who's able to blend the mental health aspect. Otherwise, we could do more harm. But that was a very practical point of why I went in that direction.
Yeah.
Okay, so did you look, I'm sorry, quick follow-up question. Did you look for, I'm a care manager, so I'm also in MSW school. So super interesting stuff. Was your approach to look for an LCSW or LMSW who was spiritually certified or practicing, or the reverse? You went to look for a spiritual counseling who was also certified in therapy and counseling? What was your priority?
My first priority was to have Elise take care of it. So
which I did. So how it actually unfolded for this case. So I'm a licensed mental health counselor, and I'm part of, various groups, for New York State. And it came across one of those groups. Someone was promoting, literally the day after Dr. Kent did his evaluation, someone was promoting their specialty of spiritual counseling, and they were also a licensed mental health counselor. And I was like, perfect. And it ends up that he is, a pastor, I believe he was, but he also has his LMHC. And in looking through his website and kind of doing some research, it did seem as though he very well melded the two and would have a good perspective. So it kind of fell into our lap as the recommendation I passed on to the coordinator. But for us, within START, we obviously want the service to be accepted. And with this family, as Dr. Kent spoke about, they are very religious and they do reject traditional counseling. So it's also about finding someone that they will accept and allow their son to participate with. So we have to the way we present it, the way we coordinate with the new provider, we also have to keep that in mind, because if they come forward too much from the LMHC side, it's going to be rejected before it even gets started. So we want to also work with the system and what they're willing to accept. This individual specifically is a part of several Bible classes, and we had some concerns as to what he was hearing in these and how he was interpreting that information. While he was at our resource center, he made several concerning comments about, what his faith was telling him he needed to do and how he needed to act. And so we wanted to ensure that he's receiving correct information that was also in line with his family's beliefs. There was also a high level of preoccupation, which the family not by any fault, but was perpetuating to a small extent of every time an issue came up throughout his life, and he had autism as well as psychiatric diagnoses, you know, the solution was religion. And again, that's their beliefs, and we honor that culturally, but we also want him to build his network. So that was kind of the direction that we went. And again, the provider kind of fell in my lap. I didn't have to actually search for it, and then provided it to the coordinator to look further into. But so again, we want to find someone that not only has the qualifications on both sides, but also that the family will accept. So there's that balance. Yeah. Something that START just really believes in is not just access to a provider, but appropriateness of the provider. So it's not good enough that they have a therapist. We want them to have a therapist that can meet their needs, you know, regardless of this religious piece, just in general. You know, if they need trauma therapy, but they're seeing a therapist that isn't able to provide that, then it's not the most appropriate therapist. It's not good enough that they just have somebody. It needs to be the most appropriate. So in this situation, it was an interesting mix between the religious component and the counseling. But those are great questions. Any other questions regarding the topic? Or comments?
Well, it's not a question, but I just wanted to sort of piggyback on everyone. I guess especially Denise. I was reminiscent of, especially since I just came from vacation down home, of I'm glad that mental health and the criminal system, the legalities of it, the understanding of it has come so far, has been built up, that individuals are able to be caught in time or addressed in time, so that situations do not develop into negative ones. I was reminiscent of Morris Mason, who I don't know if anyone's heard of him. My family, my generations grew up with him, literally around the corner, down the street, where he caused mayhem, murder, torture, burnings of individuals, of friends of mine and my siblings. But it was because he was so misunderstood and he was so brushed aside, that he could have been, he was one that could have been diagnosed earlier. He was one that others could have been saved, instead of him just continually being brushed aside. So I'm glad that that things have come thus far and has built up, so that we're able to, I guess, assist the legal system and sort of halting any, oh, sorry, so sorry.
Okay.
So I'm glad things have come so far positively. Yeah.
Absolutely. Yeah, I know I want to say it was just a few days ago, there was another mass shooting in California, I believe. And, you know, I was listening to the radio on my way to the office just the other day, and, you know, they had someone on that, you know, ex-girlfriend or someone that knew him, the individual, and they, you know, were talking about his mental health and things like that. And it just made me, you know, really upset, because I was like, if they just got him treatment, you know, maybe it would have been different. And that discussion comes up a lot after these mass shootings that we have unfortunately been dealing with as well. So I agree, Mona. I'm glad it's taking a turn. Just recently, Lisa on our team and Jennifer Rossi just met with, I believe it was Jennifer Rossi, met with, or Brittany, I'm sorry, it was Brittany, met with a member of a local law enforcement department to provide some education and training. And it's definitely something that's needed more of, you know, to start from that perspective of when they get called, you know, for a psychiatric reason. You know, we hear all the time that they're handcuffed and, you know, how they're treated. And again, that we're calling them for behavioral support, we're calling them for psychiatric, and it turns into a different situation. But that training will go further into these situations as well, where criminal activity has happened, but again, the person is impaired, and giving them that education. And again, obviously, a lot of us know on this training that part of START is to, you know, build the capacity of the community. And so a training like Lisa and Brittany had recently done is really addressing that. And I know we need to do more of that, for not just when they get called to a house because of a behavioral symptom, but also to be able to detect that something might be off and that this person maybe needs a little bit of a different care if they're attending to a criminal situation as well.
Hi, it's Alex from New York Star, Quality Assurance Manager. I also want to segue with what you just said, Elise, about training for the staff in the criminal system, supporting people that are incarcerated. There's a Netflix show called Stateless, and also the idea of trauma-informed care, because the lady had suffered a rape and was traumatized by that. And the way the staff, the cop, handled her episode, because they didn't detect that she was having a mental health issue, and the way they physically intervened actually reenacted the trauma scene for her. So I think definitely that's an area that I'm happy there's progress made, but that definitely should be a big focus.
Absolutely. Thank you, Alex. Okay. Does anyone have any specific recommendations for our case, Alice, who is still in the midst of her legal proceedings? You know, I know we mentioned a couple of things throughout the training that we'll have Liz kind of summarize, but anything specific that anyone's thinking? Okay, so Liz, I'm going to throw it to you, just if there's anything that you gained from the training that you want to kind of support the system with as Alice continues to go through her legal proceedings.
Hi, yeah, well, hopeful that Alice can be redirected from not to commit any additional crimes, and, you know, that I can assist her system with, you know, supporting her with some of the things that she needs. Wishing, you know, that she has increased opportunities for growth, where she can expand her horizon, probably keep her busy more productively, like educational based services, maybe exploring her interests, uncovering her the strengths, helping her to define her strengths and build her self-confidence, and most important, to assist her with focusing on her dreams and aspirations for life. And just, you know, keeping her, you know, out of, trying to assist her, you know, to stay out of trouble, but also not interfering on the things that she wants to do in life and her goals.
Yeah, I think it'll be important as she continues her legal proceedings to think about what got her into those situations in the first place with her executive functioning and her decision making and her social deficits, and, you know, provide her those clinical supports in those areas so that, you know, when she does sit in front of the judge, there are things that are already in the works. The other thing too, and it came up on Andy's slide and I had brought it back to Alice, was, you know, assisting her legal defense to really kind of investigate her at the time of the crime. You know, what was going on? Like Dr. Kent said, was there a medication change right before? Was there something going on that impacted her to a higher degree? It's not just about how she is acting at this moment. It's really about what she was at the moment of the crime. So kind of investigating that with the system, with her family, about her medication. I think Dr. Kent even said, like, you can get the pharmacy printout and learn to see if there were recent medication changes and things like that, and providing that information to her legal defense so that we can try to get the felony charges lowered and, you know, keep her out of jail and keep her in the rehabilitation in the community residence. Absolutely. All right. Well, thank you all for joining us. As Dr. Kent put a plug in, next month will be a case with Denise Levino, and it will be Tourette's. And that CET will be facilitated by Dr. Kent, as well as Dr. Denise Bronzino, our psychologist through START. And then the following month, Dr. Kent and I will be back together, and we are going to actually be doing another little bit of a different topic, the impact of behavioral health symptoms on family dynamics. So really talking about, you know, how things occur in the home and how that impacts the family dynamic. So I think that is going to be another really great topic. Again, not to put any blame on family, but how those dynamics can affect what we see and what to do about it. So I hope you all will join us. These CETs are monthly, typically the fourth Friday of the month. If you are not receiving any invites and you would like to, you can get invites through our office manager, Shirley, and her email is sreed, REED, @familyres.org. And we hope to see you again soon. Thanks, everyone. Have a great holiday weekend.